colleagues, friends, herzlich willkommen, liebe Gäste, Kollegen, Freunde, laipni lūgti viesmīlīgajās mājās, mīļie viesi, kolēģi, draugi. Es runāšu latviski. Please take your headphones. I will speak in Latvian language. Latvijas Universitātes juridiskā fakultāte jau kārtējo reizi ir sapulcinājusi plašu viesu loku no mums draudzīgām universitātēm. Tā ir iespēja satikties sadarbības partneriem, lai visiem kopā runātu par to, kas šobrīd ir svarīgs Eiropā. Un tā kā tiesiskas demokrātiskas valsts galvenā vērtība ir cilvēka brīvība, cilvēka cieņa, tai pašā laikā jau 11 gadus Eiropa nav dzīvojusi mierā, drošībā, kārtībā. Viss sākās ar Dienvidu Eiropu, ar bēgļu krīzi, tad sākās pandēmija, tad ir kara darbība dažādās Eiropas vietās un apdraudējums nav tikai Krievijas iebrukums Ukrainā, arī bijušajā Dienvidslāvijā ne visur ir mierīgi. Un šobrīd arī Izraēlas-Palestīnas konflikts atsaucās pilnīgi negaidītā veidā arī Latvijā. Jo Latvijas augstskolā mācās studenti gan no musulmaņu valstīm, gan no Izraēlas. Un Latvijā nekad nav bijuši konflikti starp musulmaņiem un mozusticīgajiem, bet šobrīd tā mums ir. Vai šie konflikti ļauj valstī kļūt par policijas valsti, lai garantētu mieru, drošību un aizsargātu vismaz cilvēka cieņu? Vai arī mums tomēr ir jāsaglabā brīvība? To mēs visi tuvākajās 2 dienās, daudzās sekcijās, dažādās tiesību nozarēs noskaidrosim. Mūsu konferences nozīmīgumu saprot arī Latvijas valsts, un man ir milzīgs prieks šodien dot vārdu Latvijas Republikas tieslietu ministrei, tiesību zinātņu doktorei Inesei Lībiņai-Egnerei. Lūdzu, vārds jums.
Labrīt, cienījumā Aspavs kundze, cienījumā dekāns kundze, visi klātesošie konferences viesi. Es tiešām esmu pateicīga par iespēju jums šodien šeit uzrunāt tik nozīmīgā jautājumā Universitātes juridiskās fakultātes kārtējā starptautiskajā konferencē. Latvijas konstitucionālās vērtības veido Latvijas valstiskumu, mūsu konstitucionālo identitāti un likuma vara, valsts valoda, kultūra, teritoriālā integritāte, cilvēka cieņa, visas Satversmē un cilvēktiesību dokumentos nostiprinātās cilvēktiesības, tās ir mūsu pamatvērtības. Pamatvērtības, kuras nepārtraukti tiek izaicinātas ar vien jauniem sarežģījumiem, gan nacionālajā līmenī, gan globālajā līmenī. Un šodien, kad tik daudz saprotam un zinām, ka Krievijas agresijas karš Ukrainā un ar šo agresiju saistītās hibrīdu karš pret Latvijas valstiskumu ir klātesoši, tas liek meklēt jaunus risinājumus arī tiesību zinātnē. Kā veicināt mūsu sabiedrības noturību pret hibrīdu draudiem, kā paši aizsargājošās demokrātijas principa iedzīvināšana ir aktualizējusi jautājumu par to, kā samērot personas brīvības neaizskaramo kodolu ar Latvijas valsts drošību stiprināšanas pasākumiem. Drošība un cilvēktiesības, tās nav un nevar būt konkurējošas vērtības, kas vienot izslēgt. Tās ir vērtības, kuras ir cieši kopā. Un tām vienmēr ir jābūt līdzsvarām. Un arī šis atrastais līdzsvars nekad nevar būt konstants. Tas ir ļoti mainīgs. Un to ietekmē ar vien jauni ārēji izaicinājumi. Tik tiešām šā brīža ģeopolitiskajā situācijā ir mērāma liela ietekme arī uz tiesību politiku. Un regulāri ir jāpārskat šis līdzsvars starp personas brīvībām un sabiedrības kopīgajām interesēm. Un tas ir arī patiesi izaicinājums likumdevēja izpildēji un tiesu varai Šis līdzsvars ir meklējams samērīgumā, proti valsts drošības pasākumiem ir jābūt samērīgiem ar draudiem, ko valsts cenšas novērst. Turklāt ir būtiski, lai valsts nodrošinātu caurspīdīgumu tajos drošības jautājumos, kas var skart privātumu. Tādējādi veicinot sabiedrības uzticēšanos savai valstī. Un tikpat svarīgi ir arī skaidra izpratne par katru vienu atbildību un komunikāciju, lai sabiedrība izprotu drošības pasākumu nepieciešamību un to patieso mērķi. Šī komunikācija izpaužas ne tikai ar ziņu raidījumiem un publikācijām, bet arī ar konkrētu tiesību politikas prioritāšu pārskatīšanu, atbildības latības paaugstināšanu par valsts drošības apdraudējumiem un konsekventu piemērošanu arī tiesas nolēmumos. Tāpēc neatsveram ir neatkarīga un spēcīga tiesu vara, kas pāraug šo līdzsvaru un nodrošina šī līdzsvaru ievērošanu, lai no vienas puses valsts drošības vārdā netiktu ļaunprātīgi ierobežotas pamatiesības, bet no otras puses, ka personas pamatiesība aizstāvus netiek vērtēts apdraudi no valsts drošības apdraudējumu un citu personu drošības apdraudējumu kontekstā. Un raugoties no starptautiskās perspektīvas, mēs dzīvojam laikā, kad starptautisko organizāciju spējas novērst cilvēktiesību pārkāpumus arī būtiski izaicinājumu priekšā. Latvijas interesēs ir stiprināt nevienu mūsu Latvijas tiesiskumu, bet starptautisko tiesiskumu, tāpēc Latvijas prezidentūra pašreizējā Eiropas padomes ministru komitejā tās ietveros viena no svarīgākajām prioritātēm ir demokrātijas un tiesiskuma stiprināšana. Mums ir jāpanāk taisnība un jānovērš nesodāmība starptautiskajā un nacionālajā līmenī, lai aizsargātu mūsu visu kopējās vērtības, cilvēktiesības, demokrātiju un tiesiskumu. Tāpēc mēs ar vienu atbalstīsim Ukrainu mūsu kopīgajā cīņā pret Krievijas agresijas nesodāmības novēršanu. Ar šo mēs stiprinam arī Latvijas valsts un pilsoņu drošību. Latvija ir viena no 32 valstīm, kas iestājušās trešās puses statusā ANO starptautiskajā tiesā lietā Ukraina un Krievijas federācija. Apgalvojumu genocīdu īstenošanā ar atsauci uz konvenciju par genocīdu nepieļaujamību un sodīšanu par to, jeb genocīdu lietām. Un šogad septembrī Hāgā Latvija ir sniegusi savus mutvāru apsvērumus šajā lietā. Mēs stiprinām arī starptautisko kriminālu tiesu ar saviem ekspertiem un papildu finanšu ieguldījumiem, lai varētu efektīvāk izmeklēt Krievijas pastrādātos noziegumus Ukrainā, kā arī aizsargāt cietušos. Latvija līdz šim aktīvi ir iesaistījusies kopumā 16 sankciju lietās Eiropas Savienības tiesā, kurās sankcionētās personas vai uzņēmumi apstrīd savu iekļaušanu sankciju sarakstā. Mēs Latviju apzināmies, ka arī starptautiskā tiesiskā kārtība un cilvēku cīņas aizsardzība kopumā ir apdraudētas gan ar tiešiem, gan ar netiešiem militāriem hibrīdu draudiem mūsu vērtībām. Latvijai kā demokrātiskai un tiesiskai valstī ir pienākums kopā ar sabiedrotiem veikt īpašas pašaizsargājošas demokrātijas pasākumus, kas noteikti ar likumu, samērīgi un nepieciešami, lai mazinātu valsts drošības apdraudējumu un garantētu demokrātiskās iekļaušanas noturību, stabilitāti un efektivitāti. Mums ir jābūt možiem, jāstiprina mūsu valsts noturību pret agresoru valsts hibrīdu draudiem, dezinformāciju, maigo varu, tā saukto tautiešu politiku un citiem centieniem mazināt Latvijas valsts neatkarību un sabiedroto vienotību. Arī mākslīgā intelekta attīstība ir papildu faktors, kas pastiprina mūsu izaicinājumus. Latvijas valdība, parlaments aktīvi darbojas, lai pārskatītu prioritātes kriminālsodu politikā, lai tā spētu aizsargāt valsts iekšējo drošību, stingri vēršoties pret kādiem valsts iekšējo drošību apdraudējumiem uz robežas vai iekšpustās, kā arī stiprinot cīņu pret vardarbību sabiedrībā, īpaši vardarbību ģimenē. Vēlos vēlreiz uzsvērt, ka hibrīdu draudi nav vairs tikai drošības politikas diskursa jautājums, bet jau ir kļuvis par būtisku apstākļu, ko tiesību piemērotājiem ir jāņem vērā, vērtējot faktisko situāciju un piemērojot cilvēktiesību standartus. Kā piemēram Eiropas Savienības tiesā ir atšķirīgs lēmums Un Eiropas cilvēktiesību tiesas lietā par Poņienko pret Latviju ir uzsvērta pienākumu vērtējot cilvēktiesību iespējamos pārkāpumus, ņemot vērā hibrīdu draudus un politisko kontekstu. Eiropas cilvēktiesību tiesa šajā lietā 2023. gada 26. maija lēmumā Poņienko pret Latviju vērtējot tiesību uz vārdu brīvību ierobežojumu nepieciešamību demokrātiskā sabiedrībā, ņēma vērā īpaši jūtīgo sociālu, politisko kontekstu Latvijā un uzsvēra, ka tā nevar ignorēt faktu, ka Latvija ir Krievijas federācijas kaimiņu valsts un Krievija jau bija iebrukusi Gruzijas teritorijā, tātad tas ir mazliet senākiem notikumiem, par ko ir lietas būtība, un militāri un politiski kontrolēja daļu no Ukrainas teritorijas. Tiesas ieskatā šie īpaši apstākļi, kur gaismā ir jāaplūko visa lieta kopumā. Un savukārt Eiropas Savienības tiesas pagājušā gada 27. jūlijas spriedums Rašturē Frāns, kurā bija iestājusies arī Latvija, tiesa, vērtējot vārdu brīvības iespējumu aizskārumu, ņēma vērā apstākļus, kādos Krievija veica savas dezinformācijas kampaņu, kā arī uzsvēra Eiropas Savienības un tās dalībvalstu noturības nepieciešamību hibrīdu draudiem, lai saglabātu demokrātisko debašu integritāti Eiropas Savienībā, vārdu brīvības aizsardzību. Un šodien, kā tieslietu ministra, es sagaidu, ka šie spriedumi uztinās arī Latvijas tiesas. Izpildvara un likumdošanas vara stiprina likumus, lai ietekmētu samērīgumu, taču tas piemērotāju aktīvas iesaistas šī rīcība var nesasniegt savu mērķi. Un tiesu varas nolēmumu lielā mērā ietekmē un veido arī sabiedrības izpratni par pieļaujumu un nepieļaujumu rīcību. Soda preventīvās funkcijas izpratni sabiedrībā par valsts drošības apdraudējumu, par valsts robežas apdraudējumu. Tiesas noteiktais sods ir ziņa sabiedrībai par konkrētu, noderīgu kaitīgumu mums kā sabiedrībai un valstī. Dāmas un kungi, mēs visi kopīgiem spēkiem nodrošinot tiesiskumu. Katrs tur, kur mēs esam, kur ir dot mūsu pienākums pārstāvēt Latvijas valsti. Mēs vairojam sabiedrības uzticēšanos Latvijai, mēs vairojam sabiedrības uzticēšanos Eiropas kopīgajām vērtībām, institūcijām, starptautiskajām organizācijām. Un mums ir nepieciešama kopīga rīcība gan starptautiskajā, gan nacionālajā dimensijā, lai tiešām nosargātu mūsu tiesiskumu, mūsu pamatvērtības. Un mums ir jāizstāv vērtības ne tikai abstrakti, bet konkrēti, jo tās šobrīd tiek apdraudētas ir sodi. Gan valsts drošība, gan personas pamatiesības veido mūsu satversmes kodolu, konstitucionālo identitāti. Un par tās aizsardzību pret ārējiem un iekšējiem apdraudējumiem esam atbildīgi mēs visi, kopā ar visiem valsts varas atzariem. No mūsu spējas aizsargāt sevi un aizsargāt cietušos ir atkarīgs arī tas, vai sabiedrība uzticas valstī, un jo vairāk tā uzticēsies valstī, jo noturīgāk sabiedrība un valsts kopā būs pret agresoru veidot hibrīdkaru. Tiesiska valsts tā ir stipra valsts, tāpēc šāda stipra valsts arī ir stiprs ierocis pati par sevi, lai predarbotos jebkādiem draudiem, arī militāriem draudiem. Es novēlu mums visiem šodien saturīgas diskusijas, jaunus priekšlikumus, kā mēs varam stiprināt demokrātisko valstu sabiedrības noturību šajos apstākļos, kā stiprināt tiesiskumu, kā izmantot to, ka tiesiskums ir mūsu kopīgais ierocis pret meliem un pret militāriem ieročiem. Aizsargāsim drošību ar tiesiskiem līdzekļiem. Paldies par uzmanību.
Paldies, ministrs. Konferences viesus sveiks fakultātes dekāni, profesoru Kristīnu Rozenbergu.
Šajā lietainajā dienā parasti ir ļoti piemērot konferencēm, jo tad, kad ārā spīd saule, saņemties atnākt uz auditoriju ir krietni grūtāk kā šādā laikā. Sveicinu aicinu jūs visus Latvijas Universitātes juridiskajā fakultātē, kārtējā mūsu starptautiskajā konferencē, kas ir veltīta tiesību jautājumiem. Prieks redzēt šeit gan mūsu pašu Latvijas Universitātes juridiskās fakultātes kolēģus, gan arī ārvalstu partnerus. Šo savu ļoti neilgo atklāšanas uzrunu šodien teikšu latviešu valodā, tādā veidā simboliski sveicinot jūs vienīgajā universitātē pasaulē, kas nes Latvijas vārdu. Šī gada konferences temats ir brīvības robežu pārskatīšana, dzīvojot apdraudējumu apstākļos. Šajā nosaukumā jau ir ietverti vairāki nozīmīgi vārdi. Brīvība, robežas, pārskatīšana, dzīvošana un apdraudējums. Katram no šiem terminiem pašam par sevi ir ļoti nozīmīgs tiesisks ietvers, ļoti nozīmīgs tiesisks saturs. Bet tad, kad mēs tos visus apkopojam vienā teikumā vai konferences nosaukumā, tad mums skaidri iezīmējās jautājums, kurš ir zinātniskas izpētes vērts, par ko var diskutēt un par ko vajag diskutēt. Un to uzskatām apliecina gan pieteikto referātu daudzskaitlīgums, gan jāsaka arī ļoti dažādā tematika. Brīvība tā ir vērtība. Es domāju, par to neviens nešaubās un vismaz atklāti neviens neatļaujas arī teikt ko pretēji. Tā, protams, ir neatņemama demokrātiskas tiesiskas valsts pazīme. Brīvība sākot no fiziskās brīvības un beidzot ar vārdu brīvību, beidzot ar brīvību noteikt, vai un kā bērns nāks pasaulē un kā cilvēks aizies no šīs pasaules. Tomēr brīvība nav absolūta. Un kā jau te tika ministrs kundzes runā iezīmēts, katra individu brīvībai ir savas robežas, kuras zināmā mērā nosaka arī sabiedrības un valsts intereses un šī un tā brīža vajadzības. Svarīgākais, sarežģītākais, atbildīgākais, un te mēs varam turpināt uzskaitīt īpašības vārdus, kas apzīmētu nozīmīgumu, uzdevums ir noteikti, kur tad ir tās robežas. Un vai tās robežas mainās vai nemainās, un ja mainās, tad cik būtiski mainās brīdī, kad rodās dažādi apdraudējumi. Arī apdraudējumi ir dažādi. Tie mēdz būt ārējiem. Dažkārt tie ir prognozēti, dažkārt pilnībā nav prognozēti un ir absolūti negaidīti. Un te jau tika spilgts piemērs minēts šajās kara darbības, kas gan ir bijušas salīdzinoši nesenākā pagātnē, gan noris šobrīd. Varbūt neizskanēja, bet pavisam nesen mēs vēl dzīvojam īpašos apstākļos, ko noteica Covid-19 pandēmija. Jā, šie varbūt ir tie ārēji apstākļi, ko īsti mēs neparedzējām, varbūt velti neparedzējām, vai vismaz neparedzējām tik precīzi. Par šo jautājumu jau ministrs kundze izteicās ļoti izsmeļoši un padziļināt, varbūt tam es nepievērsīšos, bet es teiktu, tie ir vēl cita veida apdraudējumi, un tie ir mūsu iekšējie apdraudējumi, iespējams pašu neatbildīgas rīcības dēļ radītiem, bet tāpēc arī nemazāk svarīgi, un tāpēc arī ar tiem mēs nevaram nerēķināties. Un viens no spilgtākajiem šādiem tiesiskas sistēmas, kvalitatīvas tiesiskas sistēmas pastāvēšanas apdraudējumiem ir resursu trūkums. Jo, ko mēs redzam? Dēļ resursu trūkuma, dēļ nepieciešamības novirzīt resursus cikām vajadzībām, mēs tikai vienkāršojam tiesiskās procedūras. Un ne jau tāpēc, lai sabiedrība tās labāk saprastu un lai individi justos ērtāk, bet gan tāpēc, lai taupītu. Un te ir jautājums, cik ilgspējīga ir taupīšana uz tiesiskiem procesiem, ja mēs skatāmies ne tikai uz vienu budžetu, 1 gadu, 2 vai 3, bet skatāmies uz to ilgspējīgā nākotnē. Tāpat arī ar resursu trūkumu es nedomāju tikai naudu. Šobrīd nozīmīgs tiesiskās sistēmas resursu trūkums iespējams ir atbildīgums, zināšanas un uzticība sistēmai. Un te ir jārunā gan par visu sabiedrību, gan arī par juristu profesionālo vidi, jo, ja parādās tendence, kad paši iesaistītie šajā, sauksim vienkāršot sistēmā, sāk to apšaubīt, pārāk bieži un pārāk smagi, tad rodās jautājums, kā pārējiem šī sistēma var šķist uzticama. Tāpat arī iespējams profesionālo zināšanu ignorēšana, ja tā var teikt, pat neizmantošana tiesību politikā, kas šādi tad ir raksturīga, ko mēs uzskatām redzam vispār par zinātni. Gan Latvijā, gan ne tikai Latvijā, visur tiek teikts, ka zinātne tiek teiksim, tā sponsorēta, ja, vai finansēta no valsts puses par maz. Jo ļoti bieži mūsu lēmumi, tiesību politiskie lēmumi īsti nav balstīti pētniecībā. Un to mēs arī varam redzēt, ka pēdējos gadu desmitos faktiski zinātnei un īpaši tiesību zinātnei piešķirtais finansējums no valsts puses ir krietni maz. Bet ir arī otrs virziens. Pat ja šie profesionālie viedokļi tiek izteikti, ne tikai no juristu puses, arī no citu profesionāļu puses, bieži tie tiek ignorēti, piesakzoties ar, pēdiņās sakot, grūtiem laikiem. Šie ir tikai daži aspekti, kas iezīmē izvēlētā temata aktualitāti un kam uzmanība gan vispārinātā veidā, gan arī uz pavisam konkrētiem piemēriem, kas ietilpst konkrētās tiesību nozarēs, tiks skatīti šajās divās dienās. Novēlu visiem interesantu un ražīgu šo konferenci, un lai tai noslēdzoties, katrs no jums aizietu ar vismaz vienu jautājumu vairāk par to, ko vērts padomāt, vēl papētīt un vēl vairāk padiskutēt. Jo tam jau arī tās zinātniskās konferences ir domātas. Lai jums visiem un mums visiem ražīga šī diena, ražīga rītdiena, lai izdodās un, droši vien, dodot Osakovas kundzei vārdu, lai jau ievadītu jūs konkrētajā plenārsēdē.
Paldies, dekāns kundze. Keynote speakers. Every keynote speaker has 20 until 25 minutes to speak, and I will be very disciplined. Mūsu pirmais plenārs sēdes runātājs ir profesors no Freiburgas Universitātes Franks Šēfers. Please, Professor Šēfer, floor is yours.
Thank you very much. Dear Professor Osipova, dear guests, it is indeed an honor for me to start this conference on freedom. In his famous speech on the social purpose of private law in Vienna in 1889, the German scholar Otto von Guericke called for a drop of socialist oil in private law when he criticized the first draft of the German Civil Code. This drop has turned into a broad stream of norms that purport to protect the weaker contractual party against the stronger one. The whole of private law is permeated by norms which a legislator has codified to shield the weaker party of a contractual relationship. These norms aim to create a social private law in accordance with the principle of the welfare state. This social private law is characterized by the fact that it merges public law and private law principles and thus cannot be called a liberal free private law, a pure private law, but only a hybrid law. Since the turn of the millennium, as mentioned before by the Minister and the Dean, numerous crises have been shaking social private law at ever closer intervals, from the dot-com crisis to the collapse of numerous supply chains during the corona pandemic and the following Russian-European war since 2022. The public law welfare state, with its ever greater demands for redistribution and politically motivated regulation, instead of a market-optimizing self-organization, is putting additional pressure on social private law. These two millstones, proactive welfare state and the deteriorating economic conditions, threaten to tear social private law apart. The call for the state as a savior of the private business is the last step before the state-planned economy known from the former Soviet Union or from present Russian Federation. Guericke certainly could not have foreseen all this. Nevertheless, his metaphor of social oil still serves as a legitimization for deep interventions in private law. Hardly anyone has really read Guericke's speech from the beginning to the end. but everyone invokes Gierke for the desire for more social law instead of private law. In view of this widespread superficiality, the validity or falsity of Gierke's arguments cannot be used to conclusively judge social private law, but the outcome of this analysis indicates to some extent the following considerations on the present state of social private law. Let us start with Gierke's historical arguments on social private law. He wants to strengthen domestic German law in the field of private law, hereafter referred to as Germanic law, which he claims that jurists have wrongly replaced with common Roman law. Here he follows the tradition of German legal studies, Germanistic, and the historical school of the early 19th century. 2 points are essential for Gierke. First, Gierke, Germanic law is the special property of the German people, if we follow Gierke. Second, Germanic law and Roman law are fundamentally different. Germanic law, if we follow Gierke, is characterized by the common good, Roman law by unbound individualism. The historical literature of the 19th century had already exposed such views as ahistorical and motivated purely by legal politics. They no longer fitted the late 19th century. When Gierke gave his speech in the late 19th century, the legal practice of the industrial age had long since ceased to ask about the origin of a legal norm, but about its usefulness. Legal history therefore does not provide a suitable argument for social private law, apart from the problem of drawing any conclusions at all from the past to the present. Gierke draws specific conclusions from legal history that cannot withstand critical examination. For example, he demands that the household staff of a manorial lord should be part of family law. Apparently, he had in mind the household community, German Hausgemeinschaft, of the Germanic or Middle Ages, which in addition to the head of the household, the wife and children, included the household staff. It is obvious that this demand no longer fits the social reality of the 21st century. Feudal domination shaped this environment, the very opposite of any social law. Apart from that, Gierke obscures the boundaries between family law and the law of obligations, here represented by service contract law. The 2 areas of law are based on completely different principles. Family law is characterized by the solidarity of family members due to kinship. The service contract is an exchange relationship of service for money. Solidarity under family law is only mutual over a lifetime. The historical household community of Gierke's mind is also not a suitable model for the codification of social rules in labor law, if we accept that labor law is separated from family law. 2 fundamental questions arise for social protection in labor law. First, whether this protection is originally social at all, and second, whether the state as a legislator is the appropriate actor to intervene in labor contracts. Indisputably, an individual worker is at a severe disadvantage vis-à-vis the employer. He or she has neither the knowledge nor the leverage to negotiate a contract on equal footing with the employer. For this reason, workers have joined together in trade unions ever since. They enforce the rights of their members through strikes and other actions. Trade unions pool the bargaining power of their members and multiply their private autonomy in negotiating the conditions of employment contracts. One can call this pooling of individual interests a social act, but in my opinion it is not necessary. This brings us to the second question. Trade unions are able to regulate employment relationships with employers comprehensively. There is no need for the state to interfere the employment contracts with statutory individual labor law, and in German Individualarbeitsrecht. The state should not become a subsidiary contracting partner in place of the unions, because this discourages potential members from joining a union and because it undermines the union's position vis-à-vis employers. Rather, the legislator should reinforce the freedom of trade unions and their members on a principled basis through a legal framework that decriminalizes strikes and strengthens group agreements as a form of collective labor law in freedom. The statutory minimum wage is a most striking example of what happens when the legislator acts instead of trade unions. When the legislator raises the minimum wage for political reasons to improve electoral chances, for example to deal with high monetary inflation, he invokes two economic risks. First, even higher inflation because of higher labor costs, and second, a loss of competition if the wage increase is higher than productivity growth. Let us now leave Gierke's ground of legal history and turn to his theoretical arguments. His thesis, no right without duty, is equally inaccurate, in my opinion. With this thesis, Gierke does not repeat the truism that the right of one person corresponds with the duty of another. No, a right without the duty of one or more persons to respect that right would indeed be meaningless. Rather, Gierke means something else. He merges right and duty and wants to limit the right of one person by a corresponding duty in the same person. I repeat, in the same person. Private rights are therefore, according to Gierke, always immanently limited. Therefore, if you follow him, there is no absolute ownership. The owner is not allowed to do with his or her property as he or she pleases. Rather, his concept of ownership is intrinsically and socially bound, so that he must show consideration for the collective. According to Gierke's conception, this collective does not necessarily consist of the sum of other individuals and their rights. No, rather, he has in mind constraining individual rights by the common good and other supra-individual values, all which derive from the world of public law. In this way, he hybridizes ownership into a right with private and public law elements. Gierke's approach enables the conceptual formulation of limited ownership and thus a silent expropriation even without formal legislative or administrative acts. Gierke not only strips away ownership but also the rule of law. Leaving aside these fundamental concerns, Gierke's allegation is unfounded that ownership under private law is some kind of selfish right that legalizes behavior to the detriment of other persons. The starting point is that society should tolerate the unreasonable exercise of ownership. Ownership finds its limits solely in the rights of other persons. This barrier is not conceptually immanent to ownership. Rather, it follows from the collision of rights of different persons. Since ownership, like all other private rights, is an outflow of private autonomy, ownership has no priority whatsoever. This feature in itself prevents an owner from causing damage to other persons with his or her property. Gierke's further support for a strong personality right is certainly welcome, but a close look reveals that this is not social private law at all. When Gierke calls for the protection of the personality, for example in labor relationships, he is not only referring to socially weaker persons, but in general to the right of personality as an outflow of private autonomy. This mixing of completely different principles continues to have a damaging effect in Germany to this day. Also, Gierke was one of the first advocates of a right of personality in the late 19th century. The German legislator still shies away from codifying the right of personality. If one turns now away from Gierke and looks at the question of whether private law should be social from today's perspective, one must first distinguish. The social content of a legal provision must be separated from its social effect. In principle, a social effect is immanent in every legal provision. However, it would be an overextension of the social concept to classify all private law as social law per se. The advocates of social private law want something very different. They want to merge private law and public law norms to the detriment of private law and freedom. Private law is supposed to be less free and more state-bound. This approach should be rejected for several reasons. First, there is simply no practical need for such a hybrid law. Unlike in Diege's age, the modern welfare state encompasses all areas of life and offers far more than subsidiary emergent assistance in challenging situations. Under these circumstances, it should be left to the welfare state to promote the material equality of its citizens. Private law, on the other hand, may limit itself to the complementary task of preserving the formal equality of citizens. The task of private law is therefore not substantive contractual justice, for example, the search for a fair price, no, but formal contractual justice at the time of entering into a contract and by safeguarding the principle pacta sunt servanda. Housing rents in particular show that this complementary division between private law and the welfare state governed by public law is the right way to go. Due to the housing shortage of the First World War, the German legislator created a complex set of rules to protect tenants. State intervention in a system as dynamic and complex as millions of tenancy agreements, however, tends to misregulate. The rules are not only difficult to understand, but also reduce the stock of available housing, at least in Germany. In conjunction with high energy prices and with state regulations on insulation, as seen in Germany today, the market for new housing has collapsed in my country. It is simply no longer feasible for investors to build rental houses. Insofar as tenants are fortunate enough to rent a home, they are also affected by the negative effects of this over-regulation. When the rent is no longer covering the expenses, some landlord might only carry out the most necessary repairs in the hope the tenants will move out again as quickly as possible due to the poor conditions of their living space. Public law measures, on the other hand, such as state subsidies for housing rents or better for home ownership, and public housing associations that build and rent out social housing are preferable, in my opinion. This enables a need-based adjustment of tenancy agreements, which can react much faster to the dynamics of the housing market than slow legal regulation. Moreover, public housing competes with private investors, which in turn stimulates competition to the benefits of tenants. Furthermore, social private law is incompatible with the foundations of private law theory, because it is, as mentioned before, a hybrid matter. Legal rules concretize vague legal principles. The principles belonging to private law limit private law immanently, whereas those belonging to public law have a transcendent effect. The difference is enormous. Transcendent limitations must be interpreted narrowly because they form an exception to the rule, whereas immanent ones do not. In a lawsuit, the defendant against the claim bears the burden of proof for transcendent limitations, the plaintiff for immanent ones. If private law and public law now principles are mixed in social private law, it remains an open question for us which normative elements are to be interpreted narrowly or broadly and how the burden of proof relates. After all, what remains as a sustainable solution is a private law that can do without social elements. The individual person is a core of private law. The sum of the individuals constitutes the private law society. Private companies like joint stock companies do not have a life of their own. They only exist because individuals want them to. The purpose of private autonomy as supreme principle of private law and equivalent of public law human dignity is not the unconditional responsibility for other individuals, but the self-responsibility of individuals. On the theoretical level, a person is responsible for every action attributable to him or her. Responsibility for others follows from self-responsibility alone. It is not socially third-party related, but non-socially related to the individual. In contrast, the common good, redistribution, and regulation are matters of public law. The attribute social is only appropriate for such a public law which is focused on the community. In view of this clear division of legal system, the principle of the welfare state and the fundamental rights of a constitution do not command the legislator to create a social private law. Similarly, the primacy of the constitution does not dictate and interpretation of private law in the sense of social private law. Now, a short sidestep. In conclusion, one could come up with the idea of interpreting every consumer protective norm as a social norm and therefore claim that consumer protection is indeed proof of the need for a social private law. However, such an equation would misjudge the meaning and purpose of consumer protection. It is only true that social protection and consumer law coincide, but they do not have to necessarily. A consumer is not merely a person without sufficient bargaining power, financial resources, and legal knowledge, but any person who is not a businessman. Consumer protection therefore abstracts from the need for protection. A social private law, on the other hand, should consequently only protect socially vulnerable persons. I will give you now one example, and more I will present in the written version of my speech. So my example stems from private insurance law. As is well known, German health insurance law is divided into, first, the statutory social insurance law under public law, and second, into private health insurance. A section of the Private Insurance Contract Act in Germany orders that an insured person who does not pay premiums can still claim basic cover from the insurer in case of illness or accident. It is all too obvious that this regulation eliminates the justice of exchange in the contractual relationship because the insured person is entitled to a benefit without any counter-performance of his or her own. This prima facie creates the illusion that the legislator is aiming the social protection of a person in need at the expense of the insurer. However, this is not the case if we look closely at the law. The legislator itself differentiates between persons in need of social assistance and persons not in need. Anyone who needs social assistance has a social claim against the Agency for Social Services for payment of the premium. The mentioned section of the German Insurance Contract Act, therefore, only concerns persons who are not in need of social assistance. In other words, those insured persons who could pay but they do not want. The solution of my own concept of a known social private law in complementary association with public social law would choose a different path here. Those in need of social assistance would still be allowed to claim social assistance for the premium, of course. Those not in need of social assistance do not deserve any insurance cover because it only would form a so-called windfall gain. This solution alone preserves the fairness of exchange in contract law and takes into account the self-responsibility of individuals. I'm coming now to my conclusions. To sum up, the historical and theoretical reasons presented by Gierke for a social private law are not convincing at all. From today's perspective, the part of Gierke's thesis worthy of approval can be classified as personality right and equal bargaining power in contractual relationships. However, these concepts are far, far away from a social private law as we understand it today. Therefore, social private law must be broken down into its two original components: free and market-oriented private law and public social law. Private law is not intrinsically social. Rather, the protection of the weaker party, for example through redistribution, is attributed to public law. Only if both spheres of law are principally, conceptually, and systematically separated from each other, they are capable of playing out their full capacity. This demand may sound revolutionary to you all, but it is no more revolutionary than Dierke's reverse plea for less liberty in private law. Free private law strengthens the welfare state of public law through higher economic growth, new jobs, and higher tax revenue. This, in turn, strengthens democracy and builds resilience against external threats. If Germany and the whole European Union want to survive in an environment hostile to democratic and liberal values, we should not put chains on freedom, but unleash freedom. Thank you very much for your attention.
Thank you, Professor Schäfer. I will please, dear audience, ask your question in coffee break. You have a half an hour to ask all questions to Professor Schäfer. Thank you. Our next speaker will be Birgitta Weber from University of Vilnius. Please, floor is yours.
Good morning, everyone. Dear Professor Otukova, dear colleagues, dear students, I see many students here. So first of all, I'd like to congratulate the faculty of law at the University of Latvia on the opening of such a big and important conference. I'm also extremely happy that I think for the first time so many representatives of Vilnius University faculty of law are attending this conference and will speak during these 2 days. Unfortunately, Dean Haroldas Šinkūnas, because of some urgent matters regarding the university, could not come, but I am really sending his best greetings, and I hope we will meet once again another time. I am also really honored to speak during this opening session, and as in summer I chose the topic which I would like to speak, and I sent my possible topic on the conference. I somehow chose such interesting, important, really practical, not theoretical topic, but actually this topic is really little discussed in Lithuania among Lithuanian lawyers. I think also Latvian lawyers do not discuss it a lot. So the topic about sanctions, in other words, restrictive measures and the impact on the activities of courts in Lithuania. As the broad war on the 25th of February 2022 against Lithuania started, different broad unprecedented economic sanctions have been started to be applied against individuals and entities from Russia and Belarus. The restrictive measures against Lukashenko and other politicians are also, of course, connected with suppression against citizens in Belarus. The legal rules regarding sanctions are being amended constantly and cover different elements, as you know, from financial services to asset trades, to trade bans, from travel bans to bans on export and import, and in many other spheres. Also, some restrictive measures are applying for possibilities to provide legal advisory service for legal entities from Russia. As Lithuania has had broad business relations with individuals and legal entities from Belarus and Russia, of course, sanctions have influenced significantly business relations and overall different spheres of private law, and of course influence some court proceedings in Lithuania. Firstly, I could mention that state institutions and also courts in Lithuania do not have actual experience in implementation of economic sanctions, as Lithuanian entities have almost zero contacts with such countries as Iran, Syria, or North Korea, and legal entities did not know so far such institutes as sanctions compliance or risk management policies, and also law firms in Lithuania have started only recently specializing in the sphere of economic sanctions. So, as you know, of course, new regulations on restrictive measures for personal entities in Russia and Belarus are applied, and the rules are often amended and restrictive measures are always extended. Right now, we have been so-called 11 packages of sanctions adopted, and the 12th package is under discussion, as far as I know, perhaps Minister of Justice, which can know better, should be adopted in coming weeks. There is also Lithuania, Republic of Lithuania law on international sanctions, with also many amendments during the last year, and there are other laws and implementing legal acts. There is also actually a commission which is responsible for coordinating implementation of sanctions in Lithuania. Representatives of courts do not participate in such commission, but different persons from different ministries, from banks, from different institutions participate in this commission, and this commission meets, as far as I know, every month to discuss different challenges. Actually, Financial Crime Investigation Service, so-called FENTA, is one of the most important institutions which is responsible for supervising implementation of financial sanctions in Lithuania. Representatives of courts quite regularly meet to present of this institution, and we discuss challenges of sanctions in Lithuania. Also, this institution has recently published guidelines on the implementation of sanctions in Lithuania. Also, participants from Supreme Court of Lithuania took part in the preparation of these guidelines, but in my opinion, so these guidelines are also really quite vague and do not help courts or some other institutions to implement sanctions. Also, as far as I know, recently, 2 weeks ago, representative of EU Commission came to Lithuania to discuss possible another guidelines on EU level, how to implement sanctions, but still different countries have different opinions, and to prepare such extensive guidelines is quite difficult. According to statistics, this information is from the middle of October. Due to Russia's military aggression against Ukraine, financial sanctions are applied in Lithuania to 10 legal entities based on links through ownership or control. The total amount of frozen funds belonging to these persons in amount is about 65 million euros and about $810,000. The total amount of incoming frozen funds is about 1.6 million euros and about 1.6 million US dollars. Due to restrictive measures in view of situation in Belarus and Belarus involvement in Russia's aggression against Ukraine, funds in the accounts of 7 legal entities and 1 individual are currently frozen, and it's totally about 26 million euros and more than 8 million US dollars. So in my opinion, these numbers are quite high in Lithuania, but we could have been much higher, as Lithuania is not really efficiently implementing sanctions, and as now we are actually one of the biggest importers of wine or cars in Kyrgyzstan or Tajikistan, so that means that we are really, I think, in my opinion, not implementing sanctions in the proper way. While speaking about challenges to court proceedings in Lithuania, so I mainly have in mind recognition of court judgments rendered in Russia and Belarus, and also judicial proceedings out of monetary claims or claims out of financial services. There have been several cases regarding allowance to invest in some legal entities which have national importance for Lithuania and national security questions were raised, but these cases were not public and I cannot really analyze this case. There have also been several cases regarding transit and regarding Lithuanian railways, but we are also really not really public, so I cannot also discuss it in a proper way. I can also mention that bilateral agreements with Russia and Belarus on legal assistance and legal relations in civil, family and criminal cases were signed in year 1995 agreement with Russia and with Belarus in 1993. Since then, these agreements have not been amended at all, and it is interesting to note that in these agreements, public order is not really straight said that it's a ground not to recognize a judgment of Belarus or Russia. Some politicians and prosecutors started last year discussions about possibilities to terminate these bilateral agreements, but these two agreements are still in force, are now applied in certain cases. As far as I know, so for example, Lukashenko adopted a decree that the judgments of countries which are not friendly must not be recognized in Belarus and should not be enforced. About Russia, I think that similar rules are adopted, but I am not sure. I also can mention that the Court of Appeal has exclusive jurisdiction to recognize judgments of foreign countries and to allow them to be enforced in Lithuania. After the decision of a panel of judges, the Court of Appeal is rendered, it is possible to file a cassation appeal to the Supreme Court of Lithuania. While analyzing decisions of the Court of Appeal of Lithuania regarding recognition and judgments rendered in Russia and Belarus, it looks obvious that legal practice is not uniform and different panels of judges have different opinion on the recognition of such judgments. I will give several examples. So, for instance, in the middle of September this year, the panel of judges of Court of Appeal recognized the judgment rendered in Russia. It was noted in the decision that the applicant, private company in this case, is not directly included in the list of sanctions. Such conclusions were made notwithstanding the fact that the Lithuanian company provided evidence that the applicant, Russian company, has many close links with EU sanctioned persons and the Russian ruling regime. The main beneficiary of the applicant conducts joint business with EU sanctioned persons and is a shareholder of Luzhniki Stadium, the main stadium in Moscow, and presented photos of him and Vladimir Putin, photos of this year. But the court stressed in the decision that public order and international private law must be understood and interpreted in a narrow manner. As far as I know, the cassation appeal is presented to the court, but is still not accepted, so perhaps we will have also the ruling of the Supreme Court. Such and similar decisions were taken by the court, notwithstanding the fact that the Supreme Court of Lithuania in 2022 in November has already quite clearly stated in one ruling that the Article 19 of the agreement with the Republic of Belarus, the legal aid is not provided if a provision may harm the sovereignty or security, rights or legitimate interests of the citizens of Lithuania, or contradicts the basic principles of its laws, and it must be interpreted as including the main principles of European Union legislation. The court stressed that the sanctions of the European Union fall within the scope of application of this article, and the corresponding sanctions may be the ground to refuse to provide legal assistance, including not to recognize the judgment of Belarusian courts. Actually, this week also Supreme Court issued one ruling in which it said that it is possible in some cases to recognize the judgments of Russia from Russian Federation, but still the enforcement procedure should be suspended till the sanctions are terminated. Such position also can be found in the quite many judgments of British courts. So actually, the Lithuanian Supreme Court used these decisions of British courts to interpret the law in such a manner. Prohibition to perform obligations out of transactions which are not allowed according to the sanctions, and the freezing of assets is an important part to safeguard the efficiency of agreed sanctions between member states. Article 7 of the Lithuanian Law of International Sanctions states that transactions entered into the obligation arising prior to the establishment of implementation of international sanctions in Lithuania must be terminated without delay unilaterally and by agreement between the parties, or their performance must be suspended during the period of implementation of international sanctions. Such position was also quite clearly stated in recent ruling of Supreme Court of Lithuania. For example, in September 2023, it was stressed that if a certain person is not formally included in the list of sanctions, it does not mean that such sanctions regime is not applied to him. The fact a person who is included in the list may stand behind him. The contrary of interpretation of the law would mean that the sanctions would become ineffective as establishment of a mailbox company formally unrelated to the real owner or beneficiary would be sufficient to bypass international sanctions. The court stressed that every legal person, entity, or body must independently regardless of the opinion of state institutions, such as Financial Crime Investigation Service, for example, must assess the possible connections of the business partner, client, or other person with whom legal relations are established or started. The entity is subject to the European, if its entity is subject to the European Union sanctions, and decide on the possibility of legal relations with such person. So that every legal entity bank has its own obligations to see all the connections with business partners. Actually, notwithstanding such rulings, still different judgments can be found in different courts of Lithuania. For instance, I found one case, they even, court of first instance, even agreed to start a bankruptcy case against Lithuanian company which did not perform agreement for Russian legal entity, and only court of appeal instance changed the ruling and did not agree that the bankruptcy case should not be started because the Lithuanian company performs all other duties with all partners, different partners from different foreign countries. So such examples show that Lithuanian courts have quite different positions towards implementation of sanctions, and legal jurisprudence of the Supreme Court of Lithuania is not always important to the other courts. It is still judges still not understand that he or she has obligation to see if the case is not connected to the sanctions. Actually, I think that, in my opinion, judges do not have enough skill or knowledge about the sanctions, and discussions regarding proportionality, legality, cooperation, and other legal issues are necessary. Also, actually, courts do not have system to find legal information about persons to whom the sanctions are applied. Actually, for example, different law firms or Vilnius Court of Commercial Arbitration have already bought different systems which help to find information and to find information about sanctions quite easily. Put simply, as far as I know, as far as I ask judges, they just Google many questions and they use Google to find the most information about sanctions. Such examples show that still cooperation between institutions is needed, and cooperation between judges and cooperation between, I think, judges from Lithuania, Estonia, Latvia also is needed to find cases about sanctions. And also I think what is needed, and what also judges told me, that for example, Ministry of Foreign Affairs would be more active to presenting information about sanctions, and that they would have some list of persons who have sanctions or who have already cases in Lithuania, that the court could see all the persons who could be involved have some connection with the sanctions. So I think I would like that the war would have stopped already, and that we will not speak about sanctions, but I'm pretty sure that the sanctions will be also part of our future. So I think it's not the first such speech about sanctions, but not the last one, and I hope that we will find more and more better judgments of Lithuanian courts and of other countries. So thank you very much, and if you have any questions, we're doing coffee breaks now, so thank you very much.
Nākamo aicināšu runāt profesoru Kačevskas kundzi. Es nezinu, kādā valodā profesors runās. Latvijas Universitāte.
Professor Osipova, Justice Osipova, ladies and gentlemen, I have chosen to speak in English because I am representing the International Department of University of Latvian Faculty of Law. And I would like to talk about revisiting the limits of freedom in arbitration law of Latvia. And I would like to discuss whether this will be the end of the black sheep's era in arbitration law. Autonomy and freedom are the fundamental notions of arbitration. The parties are free to opt out from the court proceedings and opt in into private forum. They can choose arbitrators, procedure, place, language, applicable law to the merits, and even soft law. In essence, by their private agreement, the parties give the right and power to private judges, arbitrators, to render a decision and a vote binding to them. These are basic principles of modern arbitral legal order, having unified and transnational nature. Moreover, modern arbitral legal order is strongly influenced by natural law, because the players of international arbitration law sets the rules addressing today's needs and complying with economic reality and conforming to the needs of international and national trade. This reality of legal theory of arbitration, it was developed already in 1933 by Berthold Goldman. It was followed by Pochard and my beloved, late, unfortunately, Emmanuel Gaillard. Knowing these fundamentals of modern arbitral legal order, there is a question why Latvia is the black sheep in this arbitration family. Thus, the aim of this presentation is to show how our legislator has limited freedom of parties in arbitration and stepped back from the modern arbitral legal order and in principle of party autonomy, stepped back from the principle of party autonomy, and what were and are threats or consequences departing from this modern legal theory and practice, and what are the solutions, and whether we can expect the end of this black sheep era in Latvia. What is the legal framework of modern arbitral legal order? The main source and legal standard is UNCITRAL model law on international commercial arbitration. It was adopted already in 1985, it was amended in 2006, and it is transferred as a national law in 88 countries as a national arbitration law. Thus, we can say that arbitration law is practically internationally and nationally unified and harmonized. It's predictable. Latvia has not followed model law. Therefore, we are black sheep. Theoretically, the Westphalian model allows each state to have its own views prevail without regards to what other states will do. A state can, for example, consider that an arbitration agreement that provides for ad hoc arbitration is not enforceable, as did Latvia or China. However, in case of arbitration, so-called Westphalian model is unsatisfactory. Because following Westphalian model, Latvia has lost its attractiveness as a seat of international arbitration, and that's again why we are black sheep in this arbitration family. And let me show you a couple of examples where I see this departure from this modern arbitral legal order. And the biggest problem and the biggest issue is the number of arbitral institutions. Namely, in 1998, when a legislator introduced the chapter arbitration and civil procedure law, it did not added the special limitations who can establish the arbitral institution. After those amendments, the arbitral institutions emerged like mushrooms after the rain. And already in 2014, we had more than 200 arbitral institutions in Latvia. Every my student, almost every my student, every business had its own so-called pocket arbitration. Normally in normal world, in a country, there is one leading arbitral institution. Again, legislator in 2015 tried to reduce the number of arbitral institutions, however failed again, and now we are having around 60 arbitral institutions in Latvia currently. This reform did not achieve the goal to reduce the number of arbitral institutions, but also it actually made another great mistakes and departure for modern arbitral legal order, and that concerns the arbitrators. In 2015, legislator provided in the amendments of the law that in order to serve as an arbitrator, a person shall provide that she or he has a good reputation, no criminal record, what is okay, but also this person, the arbitrator, shall possess a law degree. Thus, the parties are limited to appoint non-lawyer, for example, construction or finance specialist, to settle their dispute. And this does not correspond to principles of modern arbitral legal order. Another departure from modern arbitration legal order is that Latvia introduced mandatory list of arbitrators. Each arbitral institution should have mandatory closed arbitrators list. This minimum of 10 arbitrators. There are no reputable international commercial arbitration institutions having mandatory closed lists of arbitrators. And those new requirements in Latvian law not only limits the party autonomy, because parties cannot agree or appoint an arbitrators out of this list, but also may affect the independence and impartiality of arbitrators. Particularly, if one goes through all the lists of those closed lists of arbitral institutions in Latvia, and I have done so, we see that in those lists there are only minimum required arbitrators, namely 10. So, particularly if we think that we need 3 panel arbitrators, it would be difficult to find among those 10 arbitrators the particular expertise in specific of dispute, knowledge of foreign language, and there will be a lot of conflicts of interests. Moreover, among those lists, among those arbitrators in those lists, there are brothers, family members, other family members, there are close colleagues from the same law firm. Again, we can have a particular threat of the conflicts of interests. And in practice, this understanding of arbitrators and arbitration institutions' independence and impartiality is very, very weak. The arbitrators do not disclose to the parties any circumstances which may cause reasonable doubt as to objectivity and independence of this person. There is no tradition in arbitration in Latvia to fill out the written form of independence and impartiality. And one arbitrator from list can be appointed many times in different cases with the one and the same claimant per year. What is fundamental derogation from international standards. The second major departure from this classical arbitration is that Latvia do not have almost no court assistance in arbitration proceedings. The model law, for example, provides that court's role with respect to constitution of the arbitral tribunal, the powers of arbitral tribunal to order interim measures, and of course, model law provides the setting aside of arbitral award procedure. However, historically, Latvia has not adopted, and Latvian law lacks the setting aside of arbitral award procedure, and this is major departure from modern arbitral legal order. We see at least in the theory, the setting aside procedure must be available in Latvia for arbitration awards that fall within the scope of the European Convention on International Commercial Arbitration. Firstly, because Latvia is party to this convention. Secondly, because this convention provides for setting aside procedure. However, the civil procedure law does not contain a procedure for that. This is an obstacle to an actual exercise of setting aside procedure, even those few cases when it's mandated by international law. Scholars have insisted for years, and I quote, total exclusion of setting aside proceedings. The hypothesis is rather straightforward, a legislative approach failing to provide for the annulment mechanism arguably violates arbitrating parties' rights of access to a court under Article 6.1 of European Convention on Human Rights. The Constitutional Court has consistently underlined the problem, and every time doing it with more force. In 2005, the Constitutional Court, expressed doubts whether a system without setting aside mechanism was optimal, but concluded that the state could compensate for the absence of such mechanism by exercising control over the awards during enforcement proceedings. However, the Latvian legislator remained deaf to the court's doubts. Again, in 2014, the Constitutional Court rendered another judgment with another obiter dictum urging the introduction of the setting aside procedure in 2014. However, in the law, in EU arbitration law of 2015, the setting aside procedure was not included. In February 2023, the Constitutional Court moved from obiter dicta to action, in finally ruling that the absence of the setting aside procedure was unconstitutional and requested that the legislator created the procedure. Due to the judgment of Constitutional Court, the Ministry of Justice established a working group to develop the amendments to arbitration law and civil procedure law and to reintroduce the setting aside procedure. But the followers, like me, of modern legal arbitral order urged the ministry also introduce other specifics that are provided in the model law, so that Latvia would follow model law. For example, introduce state court assistance in arbitral proceedings, introduce compulsory execution of ad hoc awards, and it was suggested that also mandatory list of arbitrators should be waived, and stricter rules for disclosing the facts that may influence the impartiality of arbitrators introduced. Hopefully, in 2014, we will stop following the Westphalian model in arbitration, and we'll start a new era of arbitration in Latvia. And Latvia will integrate in international harmony of arbitration, and we will not limit the freedom of the parties in arbitral proceedings. Thank you for your attention.
Our next speaker will be Professor Tavits from University of Tartu. Please, the floor is yours. Our speakers are very disciplined, and I see we have 10 minutes for questions at the end.
Right. Good morning, everyone. First of all, I would like to thank the Latvian colleagues for organizing such interesting and fruitful event for the 2 days. Looking at the programs, we can see that there's a lot of questions that we have to discuss, and I hope that we will do that. And now I will continue with my presentation. My presentation is dedicated to the elderly people in the society, and especially to the state responsibility about providing the help to them. As Professor Schäfer started already, let's say early in the morning, with some, so to speak, small pieces of social oil in private law. I will continue with the social oil, but not in the private law, but still staying in the public law. If we look at the moment what's happening in the society as a general, then we can see that those changes that are now happening show us one important tendency. First of all, the positive tendency is that the people are living longer and their health is better. But at the same time, what we can see or what one can observe is the fact that the number of the younger people in the population is not increasing. And this, of course, poses a lot of challenges to the single country, because when the people are living longer, it doesn't mean that the number of years in which a person lives healthy will be also increased, and the people are not able to participate in the labor market. So we need to deal with the question, what can we do with the elderly people in the society, and whether the state will really take the responsibility. And the second question is whether we still can rely only on the state help, or we still have to deal with the question that the family will take the responsibility of caring their members. If we look, for example, into the Estonian constitution, and we deal with the constitutional background, then we see here some interesting developments. First of all, as you can see in the Estonian constitution, the section 27 says that the family has a duty to care for its members in need. And only in the next section, section 28, we can see that the state is also responsible for the people who are in need or who need help in case of the old age. So what we can observe here is that at first sight, still the family members are those who need to take care about the members if they are in situation of need, and only then afterwards the state will take responsibility. But it does not mean that we will diminish the question of the state responsibility, because still the section 28 in the Estonian constitution gives a constitutional guarantee for everyone, not only the Estonian citizen, but also for the citizen of the third country, that they have a right to ask from the state help in case of old age and also in case of need. The one important question by this right to ask help from the state is now the question whether this right is limited or unlimited. And as you can see from this section 28, you can see that this right is still not unlimited, because as we can see, the Estonian constitution says the extent of assistance and the conditions and procedure will be provided by the law. So this means that still the legislative power can decide to whom we guarantee this help, what are the conditions, and whether everyone is still able to get this help in case of a need or in case of old age. When we now talk about this sharing responsibilities, especially in case of the elderly people, then we already mentioned that we have three actors on a scheme. First of all, single person, then the family and the public authority. But still, when we come back to this Article 28 and the state responsibility, the question is to what extent we can still rely on the state, and to what extent the state can still provide help for the elderly people. And also coming back to this right to ask help from the state in case of the old age or in case of the need, and also to the fact that this right is still not unlimited, The question is, and it is also possible according to the Estonian legislation, that the state can still delegate his obligation to a private legal entity. That's one aspect. The second aspect is to what extent the state can still say that we are not providing this help, but we have some cooperation partners, the legal entity, who really guarantees this help. And this leads us to the main important question: what is still the responsibility of the state in case of old age and a need? Is it really so that the state just finance the services? It's offering the money, but the state does not offer the services in reality, which means that the state does not provide those services. Now, when we still discussing the responsibility of the state in case of the elderly people, in this case of the care centers, the question that we have to discuss is still the responsibility of the local governments. We cannot avoid any local governments because the local governments play very important role in case of the elderly people, and especially in case they are providing services for the elderly people. According to the Estonian constitution, it has been said that the local governments decide all the local issues, but at the same time, the local governments have to perform also the tasks that will be delegated to them by the state. And when the state says that the local government has to do something, then according to the constitution, there must be also the financial resources in order to do that. And the cost, as I said already, related to the different tasks that have been foreseen will be also covered by the state budget. From the theoretical point of view, it's very nice. But from the practical point of view, it doesn't function very well. Let's take an example. According to the Estonian Social Welfare Act, there are 13 different social services that the local government has to provide. And one of them is a so-called care service provided outside of the home. What does this mean? It means that the local government has to establish the care centers for the elderly people, and the local government has to finance them. And in order to finance them, it is also possible to ask from a single person a fee in order to live in the care centers. Then again, when we now see what kind of obligations the local government has, the question remains even more open. What is the state responsible for? Because when the constitution says that I have right to turn to the state and ask help in case of the old age and need, but as the state only finances the help, then the question is whether this right to get the protection from the state is really guaranteed. Now, in order to solve this problem about the state responsibility and about the elderly people, and especially about the elderly people who need care, Estonia took the care reform in this year. But this care reform concerned only the financing the services. And what was the main problem? The main problem was that was the political statement. The political statement said that if a person receives an old age pension, then for this old age pension, it's possible to live in the care center. There is no need that the family will take care or that the state will take care. But the concept that now the government has elaborated means that we have at the moment a triple financing system. What means that three parties are involved in order to finance a place in the care center. First of all, individual, through the old age pension, then the state will pay 1/3 and the local government will also pay 1/3. So we have again three-party responsibility, which again from the theoretical point of view is very nice, but from the practical point of view we have still problem due to the fact that the local governments, some of the local governments are not able to finance this share, and we have recently seen already some of the cases where the local governments are now suing the state in order to make clear that responsibility is not guaranteed. Now, the next point, or especially the last point, I would like to refer by this situation about the care of the elderly people in the society is the question when the state has already given the responsibility to the specific legal entity, to the legal person in private law. Then the question is about the quality of services. Because when we still stay by the Constitution and the state is really responsible for the help in case of old age and need, then the quality of services is also covered by the fundamental right, which is now really fixed in the Constitution. But when the state will still give the actual providing of services to the legal entity, which according to Sturnon is still possible, and as we can see, the legislator can say to what extent the help is granted, then the other point is important about the quality of services. Because in that stage, we do not have nothing to do with the constitutional right, but we have to do with the typical consumer protection. Because we have a private law entity, we have a customer, and when we have dispute between the quality of services, then it's the question of the private law. Basically saying the private law and the social aspect of the private law was also touched upon in the first presentation about the consumer protection. So again, the same question that I put already from the very beginning, what for is the state responsible? Because according to the Constitution, I, as a person, I have individual right to turn to the state. But when the state says, no, no, I'm not responsible because now there is a legal entity which takes care, so you have to go to them. So there are a lot of open questions in that point, and the questions are quite serious because the number of the elderly people is still growing. But of course, what I would like to stress here is the fact that the younger the person is, the more he or she ignores the existence of the duty of care. That's clear. Who thinks about it? That some that are elderly people. But anyway, if we take into consideration the demographic procedure and process in Europe, then we do not intend to ignore this problem that elderly people do exist. But of course, when we look at the reality, then the costs of implementing duty of care are increasing, but still it is important to bear in mind that the existence of the constitutional obligation from the side of the state and the right to demand from the state help in case of need and old age is still an important legal guarantee and belongs to the constitutional framework of the rights. But of course, everything depends on how much the countries are ready to contribute. That's clear, both substantially and financially. It's nothing to do. Constitutional right is very nice, but sometimes the application of this right depends on the financial resources. Let's hope the situation will be better in the future. So, thank you very much.
Thank you. I'm glad to say that we have time for discussions. Please, dear audience, your questions. And do we have microphone?
No.
I will start with a question to Professor Schäfer. Do we still have a classical Roman private law with real freedom of person in such situation in Europe? We still have freedom in private law, Professor? Professor Schäfer.
Yeah. Thank you very much, Justice Osipova, for this.
I'm still professor until January.
Okay. I guess it's a matter of concept. As we all know, there has never been absolute freedom in Roman law. It has been highly hierarchical and unfree society. I mean, what we look at Roman law, we talk about what the Panditist of the 19th century made up. I mean, they and the natural law teaching laid the foundation for freedom in private law. Of course, you're right, there has never been a completely pure private law and private law codification ever since, and there will never be any, since every codification on the core private law and on business law is some kind of political compromise. And there's also the law of the European Union with mixed legal politics and aims. On one hand, the common good, the taxpayer political considerations. On the other hand, for example, law and economics. So what I was talking about was, of course, the theoretical level of the theory of private law, and maybe also some kind of political wish list. Of course, not about the present state of private law.
We have enough freedom in private law nowadays. In Germany, for example. Do we have enough freedom for a person to choose?
Yeah, I would answer.
It's provocative, I understand.
But really, I doubt very much that we have enough freedom. In my opinion, the benchmark for freedom of a society and freedom in private law is economic success. And if we look today, say in my own country, in the Federal Republic of Germany, to the economic benchmark, yeah, we dribbled down from the ladder. We are now last in all G7 and G20 states, also due to the high energy prices. These energy prices are not only caused by the latest conflict in Eastern Europe, but also by a highly regulated energy market. As other regulations are also to mention, for example, in the health sector, and both share the same symptoms. They are very costly and highly ineffective, costing the taxpayer subsidies for the private market economy, and they bring us behind the United States of America and China, our main competitors. So I advocate for more freedom in private law, but not to unleash freedom as a means in itself, but to catch up with other countries, and it is also not to push down social welfare and the state and 2,000 years of community in Europe down to the abyss. No, it is just a theoretical clarification, and maybe also in real politics to strengthen private economy and economic activities, because we need this for higher tax revenues just to finance the present welfare state.
Thank you for your answer. Somebody has a question for our speakers? Then I continue with one question to Professor Davids. I thought about equality in the social care. Do you have in Estonia equality in social care for elderly people? If it depends on local governments, and every government is not equally rich, and it's equality is a fundamental right.
Well, thank you very much for this question. That was that is still a very important question concerning the equal treatment between now the local governments. Which means again that on the level of the state, we can still have certain rules, especially guidelines. What should be the quality of these social care services? But you are, in that sense, quite correct that the level of the quality of the care services really depends on the local governments. And in reality, it really depends on the financial resources, on the money, to be honest. We have also, and I guess the situation is the same in Germany and other countries, we have local governments which have a lot of money. But of course, in case the local government has a lot of money, usually this local government does not have so many elderly people. Because the young people live there, they are with the money. And usually when the local government does not have enough money, which means that the percentage of the elderly people is much more higher in the other countries. So in that sense, if you touch upon the question about the equal treatment, and especially equal treatment before the law, like we have also the same rule in our constitution, then that still is the violation of that principle. But the problem is, of course, whether now this, well, let's say our pensioner or whether the elderly people are really now going to the court and they will start to sue the local government. The state is rather doubtful. But even speaking about the theoretical point of view, when they will start the procedure against the state, then most probably they will win the case. But of course, also in our case, the Estonian Constitutional Court already has made one of the decisions, which also was connected to the local government and to provide the social services. And then the local government said that unfortunately we have rules, but we do not have any possibilities to offer the social services. And then the Estonian Constitutional Court said very clearly, you see, that is an obligation in the law. You have to provide the social services, you have to provide it, and in case you do not have money, please ask from the government. So from the legal point of view, it's easy. Go and ask the money, but in the practical way, we can also ask the money, but I guess that at this stage, it would be rather impossible to have this money. So in that sense, from the constitutional point, the right to get the help from the state is protected, but when we really compare on which level the local governments are and what is the capability of the local governments to do that, then we already can assume that there is a violation of the equal treatment in that sense. And that's a quite sad situation, unfortunately.
Latvia has the same problem. Some years ago, Latvian ombudsman came to Constitutional Court, and the question was about equality. Social support depends on place where person lives. And it's not equality anymore.
Yeah, it is not equality anymore. And also there is a practical question, what can we do? It's very hard to have make any proposal what can we now do, but still we have to stick on the constitutional right, and the constitutional right should be currently anyway. So that will be very long-lasting way to current this right. On the correct side.
Yeah, this is a very big problem for us, for neighbor countries, and maybe for foreign countries too, not only for neighbor countries. We have a question. Professor.
Well, maybe I will be able to speak louder.
It works.
Yeah? Oh, I'm sorry. I didn't think about the translations, actually. My question was, I think this problem is not only the problem of the formal countries of the socialist bloc, but I think it's a general problem of Europe as a whole, or of the world, as we are all growing a bit older. But I would like to ask you, how actually do the people in the regions, the people in the centers of care, how do they get to know what they can ask for? What is
right to know rights?
What is their right? Because according to my own experience, I think that the people going that are in these centers, they have, at least I'm from the Czech Republic, and we have a regulation that you have to have a certain age to be accepted, and you have to have certain conditions that you are not able to live alone. And
get information.
Not only information, but also the capacity to get to understand the information. Not all people are equal. The education of these people is different. Not everybody understands what they can ask for. If this is somehow legally regulated in your countries, or is it only a question of the understanding of people, or help of neighbors, families, or just assistance, or well, the worst actually. Thank you.
Could you answer, Professor Tālits, this very difficult question?
You see, the question is not too difficult to understand, but it is a quite broad one. I will give shortly my response to this question. This worry that, of course, our participant was asking about. When we look now what's happening in Estonia, at least in Estonia, then of course you said that the people who are in the care centers, the elderly people, we have to divide that as basically two categories of people. One category are those who do understand what's happening, and the other category are people who are really mentally disabled. That's really another problem. Yeah. That's a really difficult situation. But when you ask now, how do the people get the knowledge about the rights, or how do the people get the information what they can demand, then the only answer that I can give here is that we have to trust the local governments. Because therefore we have the care workers, we have trained care workers who should know, well, I now repeat, they should know, whether they know or not, the rights of those people who are in those centers, and there is nothing to do, we really need to trust them. It's the first aspect. The second aspect, now we come back to the family, because the family has the first responsibility to take care about those people who are in need. So this is also the obligation of the family to explain what our grandmother, grandfather, whatsoever can demand, and what are the rights and obligations. So we have basically two entities who are watching the rights and obligations, first of all, family members, and then the local governments. And usually what I can say is really based on the trust. And in case this trust is violated, then we can start a litigation in that sense. Unfortunately, this is the only way what I can see. So thank you.
Thank you. Arbitration is part of freedom, how to choose in private law some conflicts. Professor Kačerska, I'm still interested. What do you think? We have in Latvia 2 judgments of Constitutional Court. How to improve arbitration in Latvia? 3 judgments, thank you. And still, it doesn't work. And we don't have freedom, and we don't have good organization of arbitration in Latvia. What do you think? What should we do?
Previously, in 2015, there were ideas how to reduce the number of arbitral institutions. However, there were no found solution that was satisfying all those 200 arbitral institutions. My idea is that we should increase the quality of the work of arbitration institutions in Latvia, quality of arbitrators, and understanding what is to be impartial and objective, and not being biased, not using the arbitral institution for your own interests or for any other interests that are not in good faith. So my idea that is quality of arbitration institutions, quality of the proceedings, and modern law.
I thought that maybe our legal culture, we had this trauma, this Soviet law for 50 years, and we are not still restored our civil society enough. maybe this civil society and this legal culture improvement could help us to make better arbitration.
So then I have a contra question. Why Estonia and Lithuania have a modern arbitration law, and why they have this quality of arbitration?
We have answered from Estonia.
Yeah, if I may intervene for a comment, not a question. My name is Hannes Vallikivi and I'm a practicing lawyer besides being a PhD student. In Estonia, the arbitration law is not modern. It's quite old. And I think Estonia and Latvia are in a way in a similar situation. We have quite efficient regular courts, civil courts. There is no incentive for parties to go to the arbitration, except for confidentiality, but that is, speed is not an incentive, at least in the case of Estonia. But the problem is the small society and lack of impartial people. And of course in Latvia you have ruined your reputation, and it's very difficult to build up a reputation after that. But we have the same problem in Estonia. I wouldn't trust Estonian arbitration. If I really had a transaction, a cross-border transaction, then I would rather go to Stockholm or even Helsinki or even Vilnius when there are different people, not the local lawyers we have. And one phenomenon in Estonia, I don't know if you have seen the same here in Latvia, but I have seen panels where the parties appoint lawyers, but the third arbitrator, the chairman, is a judge. I don't know if in Latvia a judge can serve as an arbitrator, but in Estonia it is possible, and that's the way we guarantee impartiality of the panel. So that's my comment.
Thank you. Professor Pedro, could you add something about Lithuanian experience?
Thank you. So our law, I think, is quite modern, and we are really proud from Lithuania as a proceduralist about our law. And I think one of the incentives to protect arbitration in Lithuania is that we have really strong judgments of Supreme Court, where autonomy of arbitration is safeguarded. And really each year we have several judgments where it is stressed that arbitration clauses are really important, and courts cannot really cannot solve such cases and so on. So I think it's really important that also judges understand the importance of arbitration. I can't say that it's really popular in Lithuania, but still we have cases. Of course, also as in Estonia, so courts function quite good. You have online cases, you have Zoom and courts, and you have everything, and it goes quite quickly. So of course, speed is not one of the incentives, but I think confidentiality is a bigger incentive. And of course, the biggest cases go to Stockholm, Paris, mostly Stockholm, I think, in Baltic states, but of course we still have, of course, cases in Vilnius Court of Arbitration. And actually, today we have a big conference in Vilnius, but right now we are
Thank you. We have time for last one question.
I have a question.
Wait a minute. For translation, it's important to speak in microphone.
How would society be effective if the constitution of every democratic country stipulated that the elderly should be cared for by their families?
Maybe to Professor Kravitz. But everybody should have family. It's responsibility to marry and make children. Duty, constitutional duty.
Yeah, well, thank you very much. Well, as Professor Sipol said, that's the constitutional duty, nothing to do. But of course, the main point is when we talk about this duty that the family has to care about family members in need is sort of general duty that we have established already, not only in Estonia, but also taking into account other constitutions, or let's say not even the many years, but basically say many centuries ago. What we now, of course, have to think about it is still the problem how we will understand what is the family, the notion of the family, whether it's really now connected to the marriage, as you pointed out, or is it something else? Because as you know, we have a different understanding of the family, which means that there's a traditional family, then we have this broad family, which I don't know the English word for that. So in that sense, the obligation for the family members to take care about the members in need will still remain. There is no possibility that it will disappear. The main point is that the understanding of the family will be changed very rapidly due to the fact that there are changes in the society. So in that sense, I can say that the family will never get lost from this obligation, even the constitutional obligation. Whether we can sue the family in that point by the Constitution Code is another other point. But still, the family members will stay responsible anyway. There's nothing to do. Because we all have parents, we have the mothers, fathers, or we have the partners which have the same gender, still they are playing mother and father, and there is someone who is taking care. Of course, when really the child does not have any parents due to the different institution, then they have, of course, to question what family is. But in general speaking, this obligation remains anyway applicable.
Yeah, but our problem is that in nowadays society we have so many single persons, without partners, without children, without brother, without sister. We are individuals nowadays.
Yeah, in that sense, if you have individuals, and that's also true, we have a lot of individuals, this means that the responsibility of the state is now growing rapidly. So, which means that although this family responsibility will be in the Constitution, then in fact that's true, the state responsibility is really growing. So, which means that all of us who are sitting here, we have to contribute. Most probably that will be a specific tax for the care centers. So in case we have a lot of individuals, we have to be ready. There will be another tax we have to pay for it. So think about it. It's better to have the family than pay the tax.
We go back to Soviet Union. The childless people paid tax.
I didn't say that.
Thank you for fruitful discussions. We have coffee break. Coffee break will be downstairs. You will be provided.